Hello guys, and welcome to the last exception of the indoor management rule under the common law. The last exception discusses cases involving forgery. The authority often quoted for this fifth exception is the case of RUBEN versus Great FINGALL Consolidated. And the rationale for this decision, as stated in this case, is that the rule is designed to cover mere irregularities in a genuine transaction and not in a case of forgery. Now, in the case of RUBEN versus Great FINGALL Consolidated, the fact is that the appellant in good faith advanced a sum of money to the secretary of the respondent company for his own purpose. He advanced the money for the purpose of acquiring shares, and consequently certificate of the shares was issued to him. The seal had been affixed without authority by the secretary, who had also forged the signatures of two directors required to sign by the articles. The House of Lords held that the company was entitled to decline to register the appellant as owners of the shares, and they could not rely on the indoor management. So this is extremely straightforward and simple, where the person who you are entering a transaction with on behalf of the company forges signature or does anything that is forgery, then the company will not be liable for such forgery. The company would only be liable where there is a genuine transaction and then there is ostensible conduct which has been approved by the articles of association. Whether or not the conditions for such conduct has been met, which is the non-ostensible conduct, that is not the responsibility of the third party to look at. It is only the responsibility of the third party to make sure that the ostensible conduct has been carried out in accordance with the articles of association and the memorandum of association. But where such ostensible conduct is forgery, then according to this fifth rule, that would not make the company liable. So we are done with all the 5 exceptions. We are done with all the cases, from the English case to the Australian case to the Nigerian case. Now let us go to the rule under the CAMA 2020, which would be what I will begin in my next lecture. See you in next class.